A lawsuit begins with allegations, sometimes dramatic ones, but courts do not try every accusation that appears in a filing. Before witnesses, before discovery, before trial, the law demands a threshold test. Does the complaint actually describe a legally valid claim? If the answer is no, the case ends immediately. No jury, no testimony, just dismissal. Let's examine the gate that every lawsuit must pass through, the motion to dismiss.
One of the most misunderstood moments in any lawsuit happens before evidence is ever heard. A judge dismisses the case. No witnesses, no trial, no dramatic cross-examination. Just an order. The case is dismissed. To someone watching from the outside, that can feel shocking. People often assume the judge refused to hear the case. Or worse, that the judge ignored the truth. But that usually isn't what happened. What actually happened is that the case failed a legal sufficiency test before it ever reached the stage where facts are proven. And that test is called a motion to dismiss. A motion to dismiss is a request asking the court to end a case at the very beginning, because even if everything alleged were true, the law still would not provide relief. Notice the key phrase there, even if everything alleged were true. At the motion to dismiss stage, the judge generally assumes the factual allegations in the complaint are accurate. The judge is not deciding whether the events actually happened. The judge is asking a narrower question. Do these allegations, taken as true, amount to a legally valid claim? If the answer is no, the case ends right there. No discovery, no trial, no fact-finding. Because courts do not conduct trials to determine facts for claims that are not legally viable in the first place. Courts allow early dismissal for a very practical reason. Litigation is expensive. Trials consume enormous resources. Court time, attorney time, witness preparation, document review, jury selection. If every complaint automatically went to trial, the court system would collapse under its own weight. So the law requires something very basic before a case can proceed. The complaint must state a legally recognizable claim, not merely a grievance, not merely frustration, not merely a belief that something unfair happened. The complaint must allege facts that fit into a recognized legal cause of action. If it does not, the court stops the case before resources are spent proving facts that would not matter legally anyway. In federal court and many state systems, the most common motion to dismiss is based on what is called failure to state a claim upon which relief can be granted. This is often referred to as Rule 12b-6 in federal civil procedure. What does that mean in plain language? It means that the complaint does not contain enough legally relevant facts to support the claim being asserted. For example, imagine someone files a lawsuit saying, "The defendant hurt my feelings and therefore owes me money." Even if the emotional experience was real, the law does not generally recognize hurt feelings alone as a basis for monetary damages. So the court may dismiss the claim because the law does not provide a remedy for that allegation. The judge is not saying the event did not happen. The judge is saying the law does not provide a lawsuit for that type of harm. This is where many people misunderstand dismissals. A complaint contains allegations, not proof. At the motion to dismiss stage, the court assumes those allegations are true for the purpose of analysis. But even with that assumption, the claim must still satisfy legal requirements. For example, a defamation claim may require allegations showing a false statement, publication to a third party, or fault damage to reputation. If the complaint simply says, "The defendant lied about me," without alleging the necessary elements, the court may dismiss the claim, not because lying never matters, but because the complaint failed to plead the legally required components of the cause of action. Another misconception is that a motion to dismiss means the judge has weighed the evidence. That is not what is happening. At this stage, the court does not hear witnesses. The court does not resolve factual disputes. The court does not decide credibility. Instead, the judge reads the complaint and asks, if these facts were proven later, would the law recognize a claim? If the answer is no, the case stops. If the answer is yes, the case continues into discovery. Failure to state a claim is only one ground for dismissal. A case may also be dismissed for several other reasons, including lack of jurisdiction. The court may not have authority over the subject matter or the parties. For example, a federal court cannot decide a dispute that belongs exclusively in state court. Without jurisdiction, the court cannot proceed. Improper service. If the defendant was not properly notified of the lawsuit through legally valid service of process, a case may be dismissed. Due process requires notice before a court can exercise authority over someone. Lack of standing. The person bringing the lawsuit must have suffered a legally recognizable injury connected to the defendant's conduct. You generally cannot sue simply because you disagree with something that happened to someone else. Statute of limitations. Every legal claim must be brought within a certain time period. If that time window has expired, the case may be dismissed regardless of the underlying facts. Another thing people often miss is that dismissal does not always mean the case is permanently over. Sometimes the court dismisses without prejudice. That means the plaintiff may be allowed to amend the complaint, correct defects, and refile the case properly. Other times, the dismissal is with prejudice. That means the claim cannot be brought again. The difference depends on the nature of the defect. If the problem is procedural or technical, courts often allow amendment. If the problem is fundamental, meaning the law simply does not support the claim, the dismissal may be final. Motions to dismiss serve an important function in the legal system. They act as a gatekeeping mechanism. They ensure that courts devote time and resources only to cases that meet basic legal standards. Without this filter, frivolous lawsuits could proceed indefinitely. Defendants would face enormous pressure to settle weak claims. Courts would become overwhelmed. The motion to dismiss stage protects both judicial efficiency and fairness. It prevents litigation from becoming punishment by process. From the outside, a dismissal can feel abrupt. Someone tells a compelling story. Then the judge ends the case before evidence is heard. But remember what the judge is evaluating. The judge is not deciding whether something bad happened. The judge is deciding whether the law recognizes a lawsuit for what was alleged. Those are two different questions. And confusing them is one of the most common sources of frustration in legal commentary. Whenever you hear that a case was dismissed early, ask this question. Did the complaint actually state a legally valid claim? Not. Did the story sound convincing? Not. Did the plaintiff feel wronged? Not. Do people sympathize with the situation? The legal system requires more than a compelling narrative. It requires a claim that fits within established law. A motion to dismiss is not a shortcut around justice. It is a checkpoint. It ensures that before courts spend years resolving factual disputes, the law actually recognizes the type of claim being asserted. If the law does not, the case ends before trial, not because the judge refused to hear the facts, but because the law requires a valid legal claim before facts are proven. And understanding that distinction is essential to understanding how courts actually work.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.